Colonial and apartheid-era laws are currently under review through published discussion paper 162. The South African Law Reform Commission has recommended that some apartheid-era laws be revoked. Now, in a recent statement, the Commission said the review seeks to identify pre-1994 laws that stifle or adversely affect the exercise of expressive rights contained in Section 15 to 19 of the Constitution. Well, let's bring in the project leader in this investigation, Professor Shannon Hoctor, for more on the story. Prof, good morning to you. This is just the most fascinating story. And I'll tell you why, because we're going to go into some of the laws really that you're looking at. But talk to us about why this was an important process to embark on. Let's start there.
So the issue is really, a very good question is why now? You know, why after all this time in democracy are we only now looking at these laws? The reason, of course, is that there had to be an orderly transition, and as a result of that, many of the existing apartheid laws or pre-constitutional laws were kept in place. But faced with increasing criticism, it was necessary to embark on this wide-ranging review of these laws. And so Parliament's mandated it. The Law Reform Commission has taken up the challenge to do this. As you can imagine, particularly when we're dealing with criminal laws, it's very important to make sure that these aren't impacting negatively on the rights of individuals.
Yeah.
Because criminal law is a very blunt and powerful instrument in the hands of the state, and so it's very important then for us to have a look at all of the pre-democracy rules and laws and assess whether they're fit for purpose, whether they're necessary, whether they're relevant, whether they are constitutional.
Whether they fit the times, right? And that for
Correct.
me is what really stands out. And I think sometimes because we're 30 years into democracy, we forget that 30 years ago we were a very different country, and so even what we have down as legislation needs to reflect that. I want to bring up some of these Sunday observance laws that you've of course put forward, right? And I'm going to put that up on the screen in a moment, and you're able to see that. So this is what the Law Reform Commission has noted, right? That's a Sunday observance ordinance that was of 1838. Right, and then of March of 1838, yeah, I did say that, of the Cape of Good Hope. And then there was the Lord's Day Observance Act of 1895 of the Cape of Good Hope. Then there was the Sunday Law of 1896 of the Transvaal. I mean, we're talking about the Cape of Good Hope, the Transvaal, Section 21 of the Police Ordinance, what's this, of 1902 of the Orange Free State. Look at the wording of that. The prohibition of the exhibition of films on Sunday and Public Holidays Act, and that's actually one of the youngest ones, of 1977. Sure, it's so fascinating. And these still sit in our legislative paperwork, Prof?
Yes, that's right. And again, one could ask, well, firstly, where do they come from, and why are they still around? And the first part of the answer is that they have always been around, well, since the first ones were passed in 1665, back in the said Cape of Good Hope when the Dutch colonialists arrived. So one of the standout rules there was if you miss church for 3 weeks in a row, you could face criminal prosecution. So, but from there, Sunday observance laws, when the English colonialist power took over from the Dutch, they were reinforced. And in fact, in all of the 4 existing provinces, each of them had their own Sunday observance laws, as you mentioned, a few of those there. So why are they still around? Why are they still sitting on our statute books? I think essentially because they have become obsolete. They haven't been, enforced for some time.
Of course.
And so they've just been left as a result of that. But of course, that raises the question: why would you want to have laws, criminal laws, no less, when these are not being on your books, when they're not being enforced? And so that was also part of what we had to look at. Of course, naturally, there's also a constitutional aspect to it, because the problem with these rules is that they focused only on the Christian religion. Of course, we all like having a rest day once a week, so that's good. and there's a reason, and so you can understand legislation which mandates that. But these rules and laws were all passed, of course, with a particular religious focus in mind, and so that was also one of the things that we had to take into account, and in fact did when we recommended that that these laws be struck down.
Yeah, I mean, that's so interesting that you, all those years ago, could have faced criminal charges for missing church for 3 weeks, yes. Right? And then the idea that on Sundays you can't, show a film. My word. Obviously, yes. Laws that don't apply anymore. I want to look at this one because what you've done as well is look at the Riotous Assemblies Act, and this for me yes. really concerning 17 of 1956. And I want to put it up on the screen so that people can see it, because what it reads is for me fascinating. And follow with me. To consolidate laws relating to, so its purpose was to consolidate laws relating to riotous assembly and the prohibition, endangering of feelings of hostility between, look at this, Europeans and non-European inhabitants of the Republic, and matters incidental thereto, and the laws relating to certain offences. So obviously this spoke to, rights to protest, rights to gather, all of that, and you can imagine that during apartheid that would have been a big talking point. And I note, of course, that this was, I think it's 1956, that would have been also the year that we had the Women's March, for instance, in South Africa. And so, especially at a time like this, Prof, when we're also observing 3 years since the July riots, talk to us about the importance of this particular, I suppose, grouping of legislation. But then the problem there, I note, is the differentiation between Europeans and non-Europeans. Yes.
So of course, you can by the language you can understand it was the language of apartheid. You can also understand that these laws are passed focused on enforcing the apartheid rules, and the power differential in society would have meant that the rules would only really have been imposed on one sector of society, the disenfranchised. So it affected people's rights to assemble. It affected people's rights to express themselves. And so it was very much part of the raft of apartheid legislation that was passed in and around the 50s and 60s, and then in the rules of the decades that followed, actually. I mean, that particular act that you've mentioned, of course, was described by Justice Majid in the Constitutional Court as vile and basically symbolic of the apartheid rules and utterly indefensible. And so it is. What's interesting is many of the original security crimes that were contained in that legislation have actually now been repealed or moved into other legislation, and then which was also then finally repealed. So what remains in that legislation are the offences of attempt, conspiracy, and incitement, which on the face of it are actually rules which are applied in many constitutional democracies all over the world. But the question is, of course, we have to look at them and assess whether they are constitutional, right, whether they're necessary, whether they're relevant in today's society. Well, it's quite telling if a judge describes a bit of our legislation as vile, right? Let's look at this one, right, because I think this is really relevant to the time that we're living in right now. And this is laws regulating the workings of investigatory bodies. Now, this is, of course, speaking about commissions. So the power to appoint a commission of inquiry is a power that can only be exercised by the president or the premier of a province unless it is established by specific statutes, and its powers and functions are stipulated therein. The workings of a commission of inquiry tasked with investigating a matter of public concern are regulated by the commission. So this is interesting. I mean, we see quite a few commissions of inquiry, don't we, in South Africa? Why is this particular act important for you to look at? It says of 1947. So this is the original Commissions Act, of course, and the issue really is that the president can pass legislation or regulations really which can criminalize any kind of statements about the commission which could be taken as prejudicing or in some way anticipating the outcome of the commission, and of course so you can understand as a media person, this would impact, of course, on the right of the media to report on commissions. Similarly, the Inquests Act of 1959, similar words that apply there also, prejudice, influence, anticipate. So if you express an opinion on what might happen, again, there may be criminal consequences for that.
Yeah.
And so for those two pieces of legislation, it's obviously necessary for us to deal with these unconstitutional, potentially unconstitutional issues, because they obviously impact on the right to freedom of expression, particularly the media in this context.
Very interesting. Sure. And so what's the next step then for the Law Reform Commission?
So this is a discussion paper. So there's still opportunity for members of the public to give their view on the recommendations, and they can do that, I think, until the end of September. And once we've received then further comment, then it will go to a final report. And then from there, the legislature have the report and are at liberty to then use the recommendations, draft new legislation, as we have recommended in the report.
Yeah, really, really interesting. This has been, a really interesting and fascinating chat. Thank you so much for your time, and we'll be watching that process very, very closely. Professor Shannon Hoctor, their project leader with the discussion paper 162 from the Law Reform Commission.